Okay, let's dive into this. What you're about to see is a story about a homeowners association dispute in Arizona. Now, I know what you might be thinking. An HOA dispute sounds kind of dry, right? But stick with me, because this isn't about overgrown lawns or the wrong color mailbox. This whole case hinges on the precise meaning of just a few words, a little bit of math, and a question that ended up in front of a judge. And it all boils down to this puzzle right here. How can 9 pieces of paper, 9 physical ballots, somehow equal 11 votes? I mean, that just doesn't add up, does it? Well, that single question is what turned a simple neighborhood disagreement into a full-blown legal challenge. So let's set the scene. We're in Tucson, Arizona, at the Saguaro Crest Homeowners Association. The community was holding a vote on a truly massive issue, whether or not to completely dissolve the entire HOA. We're not talking about a minor rule change here. This was about the very existence of the association that governed their whole community. The stakes were incredibly high. So on December 11th, 2021, the association holds its annual meeting. They collect the ballots, they count them up right there in front of everybody. The result announced to all the members, clear as day. 9 ballots had been cast in favor of dissolving the HOA. The final count? 9. But here's where our mystery really kicks off. A little while later, when the official meeting minutes get sent out, the numbers have changed. The official record now says that 11 votes were cast for dissolution. So wait a minute, how did 9 suddenly become 11? A vote that looked like it failed had now officially passed. Well, as you could imagine, this discrepancy didn't sit right with at least one homeowner. He saw that shift from 9 to 11 not as some simple correction, but as a serious violation of the rules, and he decided he was going to formally challenge it. That homeowner's name was Clifford Burns, and he filed a formal petition with the Arizona Department of Real Estate. He basically argued that the vote didn't follow the requirements that were laid out in the HOA's own governing documents, its Articles of Incorporation. He wasn't messing around. He was taking this all the way to an administrative law hearing. So the heart of his complaint was this accusation right here. He alleged that what was announced at the meeting, that count of 9, was the truth, and that, quote, in the meeting minutes, the board changed the vote. In his mind, this wasn't just some clerical error. It was a deliberate, after-the-fact change to the results. Now, this slide, this is the rule the entire case hangs on, Article 15, and it's very specific. To dissolve the association, you need assent given in writing and signed by the owners who hold at least 2/3 of the votes. Keep those 2 phrases in your back pocket, in writing and signed. They are absolutely crucial. And that brings us to Mr. Burns's other big point. He actually presented the ballots as evidence, and he pointed out, hey, look, none of these have a signature line on them. So he argued, since the ballots themselves weren't signed, they totally failed to meet that clear requirement in Article 15, which, in his view, made the whole vote invalid, no matter what the final count was. Okay, so that's the petitioner's side. But the HOA, well, they had a totally different story to tell, a different interpretation of both the math and the rules. And their explanation is where we start to solve that initial puzzle of how 9 somehow becomes 11. During the hearing, the HOA's lawyer, John T. Crotty, he laid out their case pretty simply. He agreed, yup, there were only 9 physical ballots cast for. But, he explained, the rules are clear. Homeowners get 1 vote per lot they own. And in this community, 2 of the homeowners who voted for actually owned 2 lots each. And this is where it all starts to make sense. Let's just break down the math. You've got your 9 pieces of paper, right? 7 of those ballots came from owners who have 1 lot each, so that's 7 votes. Simple. But the other 2 ballots, those came from owners who each owned 2 lots, so they each get 2 votes. That means those 2 pieces of paper actually represent 4 votes. So you take your 7, you add that 4, and you get 11. 9 ballots, 11 votes. Mystery solved. So how many votes did they actually need? The HOA had 15 lots with voting rights. To meet that 2/3 requirement from Article 15, they needed at least 10 votes. And as you can see, once you tally the votes correctly, the 11 they received was just enough to clear that threshold. Okay, but what about that whole signature thing? The HOA explained their process. Homeowners got a package with 2 things, a ballot and an envelope. You fill out the ballot, you stick it in the envelope, and then you sign the outside of the envelope, which also had your lot number on it. So their argument was really about interpretation. They said Article XV requires the assent given in writing to be signed. It doesn't say the ballot itself has to be signed. They argued that the ballot and the signed envelope were basically one complete package, and that signature on the outside fulfilled the rule. The big question was, would the judge buy it? All right, so this brings us to the final showdown, right? Both sides had made their case, they presented their evidence, and they argued over the meaning of the rules. Now, it was all up to the administrative law judge, Sondra J. Vanella, to make the final call. Now, before we get to the verdict, you gotta understand this key legal idea, burden of proof. It wasn't actually up to the HOA to prove they were right. The responsibility, the burden, was on Mr. Burns, the petitioner, to convince the judge that his version of the story and his interpretation of the rules was more likely to be true than the HOA's. And on that first point, the math, the judge's decision was crystal clear. She confirmed that 11 votes were cast on 9 ballots, and that this number met the 2/3 requirement. The math mystery was officially closed. And as for the whole signature issue, well, the judge's ruling was just as direct. She noted, and this is a quote right from her decision, that Article 15 does not specify that the ballot itself must be signed. She decided that the signatures on the envelopes were good enough to satisfy the rule. So, with both of his main arguments shot down by the judge, Mr. Burns had failed to meet his burden of proof. The case was officially dismissed. The vote to dissolve the Saguaro Crest HOA was valid, and it stood. Okay, so the case is closed, but what's the big takeaway here? This whole thing is just a powerful lesson in how the fine print, the specific, nitty-gritty wording of the rules we all live under, can have absolutely enormous consequences. Let's just quickly run through what we learned, because it's pretty wild. We saw that a ballot and a vote are not always the same thing. One is just a piece of paper, while the other is a legal right. We also learned that a phrase like signed in writing can apply to an entire package of documents, not just a single signature line. This case is a perfect reminder that the fate of a whole community wasn't decided by what seemed fair, but by the precise, literal meaning of the words in their own rulebook. And that really leaves me with one final thought for you. Think about it. From the terms of service on an app you just downloaded to the bylaws of a club or an organization you belong to, what rules in your own life have you agreed to without ever really reading the fine print? Because as this case shows, sometimes the entire story is hidden right there in the details.